Hello everyone, welcome to pre-crash course for competitive exams held by VIRAT HINDUSTAN SANGHAM in association with Manifest IAS Bengaluru. So this program is inspired by Dr. SUBRAMANIAN SWAMY and it is convened by Sri Ravishankar Sir, State Education Convener, VHS Karnataka and President of Good Neighbors India NGO. So I am the Chief Mentor of your program. So this is my name, DHANUSH Kumar. I have been mentoring civil service aspirants for past 5 years. Okay, so this program is held online. It was inaugurated on 28 January. So you can watch this program every day on the YouTube channel of VIRAT HINDUSTAN SANGHAM as well as the YouTube channel of UDAYA News Karnataka. And also you can join our Telegram channel for free mentoring. So here is the link of our Telegram channel. Okay, this is your timetable along with syllabus. So we have started with polity and next we are going to take up history. So here is the link of the Telegram channel and also you can join by scanning this QR code. So that will help for your doubts clearing and concepts clearing. So you can directly message us. So how to make the best use of these classes? So senior aspirants can use this as a revision course and freshers can use this to get insights into the syllabus and clearing of the critical concepts. Okay, let's begin the class. So today we are going to discuss, we are going to begin with the concept of tribunals. So what are tribunals? Tribunals are nothing but courts of a different sort. So they are not full-fledged courts but have all the attributes of court. Okay, in the tribunals there is one peculiar thing where not only the judges, even executive can be part of the tribunal. So you have Debt Recovery Tribunal, National Company Law Tribunal, Central Administrative Tribunal, State Administrative Tribunal, Telecom Dispute Appellate Tribunal, TDSAT. So many other tribunals. So there are not only even the National Green Tribunal, not only the members from judiciary but even executive, that is expert members or technical members can also be present. So what are the constitutional provisions when it comes to tribunals? So tribunals comes under part 14A, they come under part 14A. So two articles are important when it comes to tribunal. What are the two articles? 323A and 323B. So please remember these two articles. They are very important when it comes to tribunals. Okay, so 323A, the first article talks about administrative tribunals. So what are administrative tribunals? Suppose a civil servant or a government servant is having some issues like he might be transferred or he might be suspended or he might be penalized or his promotion might be withheld. Any issues with respect to the government servants or civil servants, he can approach the administrative tribunals. So Article 323 enables the Parliament to take out the adjudication of disputes relating to the service matters, that is government service, and give it to administrative tribunals. So how many tribunals are there? So when it comes to administrative tribunals, we have Central Administrative Tribunal and State Administrative Tribunal. So Central Administrative Tribunal, when was it set up? It was set up in 1985. It was set up in the year 1985. Okay. So it has 17 regular benches, that is 17 benches at different places. Okay. So the CAT exercises original jurisdiction in relation to recruitment and service matters of public servants covered by it. Original jurisdiction means what? So the civil servants who are covered by it, mostly the central government employees and all India service employees, with respect to these employees, they can directly approach the tribunal with respect to their service matters. So they need not go through the state administrative tribunal. That is what is meant by original jurisdiction. So CAT exercises original jurisdiction with respect to these employees. So CAT is a multi-member body. It's not a single member body. It is a multi-member body. Okay. So the appointment of members of CAT is how is the appointment made for the Central Administrative Tribunal? It is based on a committee chaired by sitting judge of a Supreme Court. Sitting judge of a Supreme Court makes the recommendation via his or her committee. So what is the special thing about CAT? CAT is not bound by the procedure laid down in the civil procedure code. That is, so it is based on principles of natural justice. So civil procedure code deals with civil matters, how the proceedings has to be carried with respect to civil issues. Criminal procedure code deals with how the prosecution has to be carried out in criminal issues. So what is the difference between CRPC and IPC? CRPC, that is criminal procedure code, deals with the conduct of trial in the courts, how the trial has to be conducted. However, the penal code comes at the end. So what does the penal code do? It based on the crime, it is going to penalize the convict. That is the difference between CRPC and IPC. Similarly, even when it comes to administrative tribunal, it is not criminal, it is civil offense, civil matters. So it is not bound by civil procedure code. What it is bound by? It is bound by principles of natural justice. Principle of natural justice means there is no bound for the tribunal. It can conduct the proceedings based on the ground realities, not based on the procedure laid down in the book. Okay. So this is with respect to the central. So with respect to where does the appeals from CAT lie? It lies to the respective High Court. Earlier it was only Supreme Court. However, in the KUMAR case, 1987, the appeal was made to, the appeal can be also be laid before the High Court, respective High Court. Next comes the topic of state administrative tribunals. So similar to the central administrative tribunals, we have state administrative tribunals at every state. So not every state. So till now there are SATs, that is state administrative tribunals, have been set up in 9 states. Only 9 states. Okay. So the chairman and so even the state administrative tribunals exercises original jurisdiction with respect to whom? With respect to state government employees. State government employees can directly go to SAT. Need not by any court. Need not go through any court. Directly, any issue they have, they can go to SAT. So the chairman and members are appointed by president after consultation with the governor. Here there is no role for judiciary. So it is the president, executive, who appoints the, that is the president who appoints the chairman and members of SAT. Okay. So there is also provision for joint administrative tribunal as well. So next comes the topic of tribunals for other matters. Other matters means other from administrative issues. So which is the article? The article is 323B. Okay. So what are the other matters? The other matters may be taxation, land reforms, industry, and elections, rent and tenancy rights, and so many other issues. Okay. So this is with respect to the tribunals for other matters. What is the difference between 323A and 323B? Difference. What is the difference? So the difference is one is administrative, another is for other matters. The second is 323A, tribunals can be established only by the parliament. 323B, tribunals can be established by both parliament and state legislature. Okay. So 323A, there is under 323A only one tribunal for center and one tribunal for state, each for state. However, in 323B, many tribunals can be created. Okay. So this is all with respect to the concept of tribunals. So let us now move to the next topic, that is subordinate courts. The topic of subordinate courts. Subordinate court means what? So we have Supreme Court, we have High Court. So below this, whichever court comes, all of them are called subordinate courts. So your district courts, your municipal courts, your JMFC, your taluka courts, sessions courts, and city civil court, everything comes as a subordinate court. Okay. So what are the constitutional provisions with respect to subordinate court? So they are dealt in the articles from 233 to 237. 233 to 237. In which part? In part number 6. Part 6 of the Constitution, Article 233 to 237 deals with subordinate courts. So, okay. So, first is under the constitutional provisions. First, appointment of district judges. How the district judges are appointed. So, every district has a district judge. So, the appointment is done by the governor in consultation with whom? The state high court. Governor does the appointment in consultation with state high court. So what are the qualifications? He should not be in a government service. He should be an advocate for 7 years. So he should have been recommended by high court for appointment. So appointment of other judges apart from district judges. So apart from district judges, whoever the judges are appointed, it is called judicial service. So here the appointment is done by the governor. It is done by the governor after consultation with State Public Service Commission as well as High Court. District judge, only High Court. Other judges, the judicial office. So it is State High Court as well as State Public Service Commission. Control over subordinate courts. So the control over district and subordinate courts is exercised by which court? High Court. The respective court exercises the jurisdiction or control over the subordinate courts. So district court, so in the district level it is called district court. When it comes to cities like metropolitan cities like Bengaluru, it is called city civil court or city civil court. Okay. So district judge also means, so this question was asked in KPSC 2000, which the exam which was held in conducted in 2020 August 24. So what does the expression district judge means? District judge, the expression means a judge of city civil court. That judge is also called district judge. Additional district judge, the joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, and assistant sessions. All of them can be equated to the expression district judge. Okay. So next is structure and jurisdiction. Structure and jurisdiction of subordinate courts. So the organization of these courts, that is subordinate courts, how they are organized, it depends on the state to state. The states decide, the state government decides. So they differ from state to state. Broadly it is before HC it is, before High Court it is district court or sessions court. So a judge is called a district judge when he deals with civil matters. He is called a sessions judge when he deals with criminal matters, right? So before this we have at the lower level we have civil side, we have subordinate judge court and municip court. Civil side we have subordinate judge court and municip court. Okay, at the criminal side we have JMFC. So we have JMFC, Chief Judicial Magistrate Court and Judicial Magistrate Court. At the criminal side we have Chief Judicial Magistrate Court and Judicial Magistrate Court. So this is the broad organization, need not be the same across the states. Okay. The district judge is the highest authority in the district. In the district, he is the highest judicial authority. So the district judge, when he acts as a on the criminal, when he acts with the criminal cases, he adjudicates the criminal cases, is called a sessions judge, and he can award even the death sentence. So, however, lower level courts cannot award death sentence. It is only the prerogative of sessions judge who can award the death sentence. Okay. So, this is the broad organization. In some metropolitan cities, there are city civil courts. I already said that. On the civil side and metropolitan magistrates. On the civil side, we have city civil courts and metropolitan magistrates. Metropolitan magistrate on which side? Criminal side. Okay. This is broadly with respect to subordinate courts. What are the articles? I already told. It's from 233 to 237. National Legal Services Authority. So, your NALSA, favorite expression, NALSA, National Legal Service Authority. So, it is called NALSA. So, where is the origin? Article 39A. Article 39A, added by a Constitutional Amendment Act. What does it say? It says free legal aid to the poor. Free legal aid. So, it starts from there. When was the National Legal Authority formed? So, it was formed in 1987 by National Legal Service Authority Act. National Legal Service Authority Act 1987. Okay. So we have National Legal Service Authority. Likewise, we have State Legal Service Authority at the High Courts. We have District Legal Service Authority at the district level, and also Taluk Legal Service Authority at the Taluk level. So, what do? They provide free legal aid for the poor and needy, those who cannot afford to pay for a lawyer. So, here are the broad functions. Free and competent legal service. They also organize Lok Adalats. What is Lok Adalat? I am going to talk further. So they also organize legal awareness camps. So these NALSA or state or district or Taluk Legal Service Authority, they organize free legal awareness camps. Okay, so who are the persons eligible? So here women and children are eligible, members of ST community, victims of mass disaster. So all of them are eligible. So what does the free legal aid includes? It includes payment of court fee, process fee and other charges. So also providing service of lawyers and many other things. So next comes the concept of Lok Adalat. What is the meaning of Lok Adalat? Adalat means what? In Hindi, Adalat means court. Lok Adalat means people's court. Okay, so it has an origin in ancient India. In ancient India, we see in the movies and all, there used to be panchayats. The panchayats used to adjudicate the disputes and punish the culprits. So this has origin in the ancient India. So it is called People's Court. It is based on Gandhian principles. Gandhi envisaged each village to be a republic. Right? So what happens? These people courts, they also come under alternative dispute resolution. So what are the alternative dispute resolution mechanisms? ADRs. So we have courts. Generally we have courts. If we decide the dispute outside the courts, it is called alternative dispute resolution. There are 4 mechanisms. One is negotiation, mediation, conciliation, and one more thing is there, arbitration. So arbitration, negotiation, mediation and conciliation. So Lok Adalats also fall under the alternative dispute resolution mechanism. Okay. So here it is a easy way of settling the disputes. So what is the function? So it is an alternative to judicial justice. So they deliver, what do? They deliver informal, cheap and expeditious justice. So they deliver informal, cheap and fast justice. So what they do? So every Lok Adalats will be organized every now and then. So in this Lok Adalat, a judge, a judicial officer will sit, and on the other side one social servant will sit, and one more person will be there. So there will be no provision for legal representation. There are no lawyers in this. So the person, suppose I am a I have a grievance. So I have a grievance against other person. Both of us will be called in front of the Lok Adalats. What are the types of cases? So the cases are generally check bounce case, petty cases. So all these cases will be decided by the Lok Adalats. So per day lakhs of case will be decided by the Lok Adalats whenever they are held all over the country. Okay. So what is the statutory status? So statutory status for Lok Adalats. Do we have a statutory backing? Yes, we have statutory backing in the form of Legal Services Authority Act. National Legal Services Authority Act, that is 1987, provides the statutory backing. So every Lok Adalat consists of a judicial officer, serving or retired judicial officers. Okay, so it may also consider a lawyer and a social worker. So a lawyer is not a representative lawyer but a general lawyer who is impartial. So it has jurisdiction over any case pending before a court and any matter that is within the jurisdiction of court, and not that is, so 2 cases. One, those cases which have already entered the entered the court proceedings. They can be brought to the Lok Adalats, and also those cases which are yet to go to the court, those can also be brought to the Lok Adalats. So various matters, family disputes, land disputes, labor disputes, check bounce cases and housing finance cases, consumer grievance cases, electricity matters, telephone bills, many of them are cleared by Lok Adalats. Okay. So once the parties agree to the resolution, it is a kind of mediation. So it is a kind of mediation. So once the parties agrees, so the dispute gets settled. So if the so what is the process? The parties, both of them agree to get the matter settled in Lok Adalat, then the case comes to Lok Adalat. Or else, even if one of the person wants to go to the Lok Adalat, then also the issue comes to the Lok Adalat. Or even the court themselves can refer the matter to Lok Adalat. So 3 cases, both of them come to Lok Adalat, one of the party comes to Lok Adalat, or the court refers the matter to Lok Adalat. So what are the powers? So they enforce the attendance of witnesses. Witnesses has to come and represent, give witness, and also they can ask for any documents to be produced. They can ask for evidence. So many other things. So similar to the court proceedings, but in a flexible fashion. So the award of Lok Adalat is considered to be a decree of a civil court. Decree of a civil court. It is equal to a civil court order. Okay. So shall be final and binding. So no appeal. No appeal lies against the order of the Lok Adalat. No appeal can be made. So what are the benefits of Lok Adalat? What are the benefits? One is there is no court fee. It is free of cost. So then speedy trial. We see today more than 3 crore cases are pending in various courts. Supreme Court alone has 70,000 pending cases. So these courts ensure speedy trials. So the judges directly interact with the people who are involved in the disputes. There is no intermediary of lawyer. Okay. So this is with respect to the Lok Adalat. Permanent Lok Adalat. So can there be a permanent Lok Adalat? So to have a permanent Lok Adalat, Legal Services Authorities Act, that is NALSA Act, was amended in 2002. The NALSA Act was amended in 2002 to have a permanent Lok Adalat. Okay. So what are the reasons for having a permanent Lok Adalat? So one is a huge success of the concept of Lok Adalat. That is the first reason. Okay. So next is to provide free and competent legal service. That is another reason, and also to increase the effectiveness of judicial system. That is also a reason for organizing permanent Lok Adalat. So we have Lok Adalats for many things. That is telecom bill dispute, permanent Lok Adalat for telecom dispute, electricity bill dispute, so many other disputes. Even if you write 1 or 2 disputes, more than enough. Even petty cases can be brought to the permanent Lok Adalat. So what are the features? Features of permanent Lok Adalat. Features of permanent Lok Adalat. So it consists of a chairman who is a judge or who is a district judge. So district judge can be the chairman. So it can exercise jurisdiction with respect to public utility services. Public utility services. That is, what are the public utility services? Post, telegraph. So telegraph is not there now. Telephone, power supply. So water dispute, many other things. So it decides disputes up to how much amount? So the permanent Lok Adalat decides disputes up to 10 lakh rupees. Okay. So compoundable offences. Compoundable offences means what? Compoundable offences means those. Compoundable means an offence where the parties can come into a agreement. So they can settle the dispute. So by an agreement. What is it called? Suppose someone has cheated you of some, let's say 1 lakh rupees. So you have filed a case. So if the person comes to you and requests that please take back the case, I am going to pay the amount. So then you agree. So compoundable means the dispute can be agreed and settled among themselves. No need for court proceedings. Those proceedings are called compoundable offences. Okay, so non-compoundable offences means like crime, murder and so those things. There cannot be an agreement outside court. It has to be tried in the court itself. So non-compoundable offences cannot be brought to the Lok Adalat. That is also one of the features. Okay. So every award made by the permanent Lok Adalat is final and binding. There cannot be an appeal in any court. Okay, next we'll move to the concept of family courts. Family courts means what? Which deals with family disputes, inheritance, divorce, majorly divorce, right? Okay, marriage, family disputes, family affairs, everything. So Family Courts Act, there is an act. So Family Courts Act 1984. This is the act which forms the basis of family courts. right? Family affairs. So what are the reasons for having a family court? So many women organizations from time to time have demanded that family courts be set up because there are many cases of domestic violence and many cases where women are subjected to various kinds of crimes. So these organizations have demanded, even Law Commission has said that family court should be there. Which report? Law Commission 59th report. So the main objectives of the family court is to create a specialized court, which deals exclusively with family matters. So family matters exclusively dealt by these courts. So it deals with conciliation. I told you ADR. ADR means alternate dispute resolution. When it comes to Lok Adalat, it is mediation. When it comes to family courts, it is conciliation. Both the parties get conciled. Okay, conciled means sort of agree or come together, agree to resolve the dispute. So it also provides inexpensive remedy. So what are the features of family courts? So family courts are established by which authority? State government. In consultation with which authority? High Court. The government consults High Court and establishes the family court. So for every 10 lakh population, one family court has to be there. That is the condition. Okay, so jurisdiction. What are the jurisdiction of these courts? Matrimonial relief, including nullity of marriage, nullifying the marriage, that is cancelling the marriage, judicial separation, divorce, and many other things. Property disputes of spouses and legitimacy of a person, guardianship of children, and many other things. So it is obligatory on the part. So when you take the dispute to the family court, first they advocate reconciliation. That is, don't go for divorce. Let us settle the matter. Let us concile. So they try to counsel you. So that is the first stage. So when this stage, here social welfare agencies, counselors are involved. So here, if the conciliation doesn't take place, then the court will give an order. So that may be divorce or anything else. Okay. So here there is no provision for legal practitioner. That is, no provision of lawyer. The parties themselves represent. Okay. So this is the concept. This is the whole thing about family courts. Next, we will talk about Gram Nyayalayas. Gram Nyayalayas, the word itself is self-explanatory. Gram means village. Village courts, Gram Nyayalayas. So, Gram Nyayalayas, we have Gram Nyayalayas Act 2008. Gram Nyayalayas Act 2008. Okay. So, what does this act provide? This act provides for the establishment of Gram Nyayalayas at the grassroots level, so that justice is delivered to the doorstep of the population. So they need not come to the taluka or the district headquarters. So the justice can be delivered at the village level itself. Why Gram Nyayalayas were set up? Why were they set up? So access to justice by the poor and disadvantaged, that is the main reason. So also Article 39A, what does it say? It says free legal aid to the poor and disadvantaged. So that is also a reason Gram Nyayalayas were set up. So the Law Commission also has suggested the Law Commission report. So you know what is Law Commission? Law Commission means it is set up by the executive from time to time to renew or to give recommendations about the impending laws, to give recommendations about new laws, or also to reform old laws. So with respect to this, the Law Commission gives timely recommendations to the government. So the 114th report of the Law Commission has suggested Gram Nyayalayas has to be set up. So what are the features? What are the features of these Gram Nyayalayas? What are the features? So it shall be a JMFC court, that is Gram Nyayalayas shall be a JMFC court, judicial magistrate of first class. So the presiding officer is called what? JMFC judge is called Nyayadhikari. Nyayadhikari, it is a Hindi term, Nyayadhikari, one who delivers the justice. So this is the term, right? Okay. Next is, so it shall be Gram Nyayalaya shall be established for every panchayat. So we have Gram Sabha, we have Gram Panchayat. When it comes to local level governance, we are going to discuss it in the same class, yeah, in the upcoming times. Okay. So the Gram Nyayalaya shall be mobile court. Mobile court means what? They move from village to village. They don't have a permanent setup. So they move from village to village and go on settling the disputes. So the headquarters will be in a, suppose there are 30 to 40 villages. In one of the villages which is close to all the villages, that is at the center spot, the headquarters of the Gram Nyayalaya will be set up. Intermediate panchayat, it is called intermediate panchayat. So it is mainly set up at the taluk panchayat level. So the headquarters of Gram Nyayalaya is mainly set up at the taluk panchayat level. Okay. So the Gram Nyayalaya shall try even the criminal and petty civil suits. Petty criminal and civil suits can also be tried by Gram Nyayalayas. Okay. So the Gram Nyayalaya follows summary trial in criminal trial. So what is summary procedure? Summary procedure in criminal trial. So it means they don't adjourn the dispute to some other day. So they are going to hold the session or hold the trial continuously without break and give the judgment, that is with respect to criminal cases. So the judgment passed by Gram Nyayalayas have the effect of a decree of a district court. Okay. So here one more thing is there, they are not bound by Evidence Act. So we have Indian Evidence Act, which means only these types of evidence are to be permitted in the courts. So the Gram Nyayalayas are not bound by Evidence Act, rather they are bound by principles of natural justice. Okay. So where does the appeal lies? Appeal lies to Sessions Court in the case of criminal case. In the case of civil case, it lies to the district court. So establishment of Gram Nyayalayas. Establishment. Which are the states which have established the Gram Nyayalayas? So the central government has given up to 18 lakhs for the setup of each Gram Nyayalaya. So Gram Nyayalaya setting up, the central government has given up to 18 lakh. So there are more than 5,000 Gram Nyayalayas which have been set up. More than 5,000 Gram Nyayalayas which have been set up in various states. After this, after which act? After Gram Nyayalayas Act 2008. Okay. This is with respect to the concept of Gram Nyayalayas. Next, we will move towards special provisions for some states. So all the states, India is a asymmetric federalism. Not every state is treated equally. Before the abolition of Article 370, the state of Jammu and Kashmir had its own citizenship and also own constitution. So this type of federalism is called as asymmetric federalism. So where there is no symmetry, different states are treated differently. Okay. So which are the, what is the constitutional provision? So constitutional provision, article 20, part 21 speaks of the constitutional provision and articles. Which article? Article 371 through to 371J in part 21. In part 21, article 371 to 371J speaks about special provisions for some states. So which are these states? So these are the states which have special provision. So what is it with respect to Maharashtra and Gujarat? So article 371. So 371 article itself speaks about the special provision for Maharashtra and Gujarat. So what does it say? The article says there is a separate development board for Vidarbha and Saurashtra and Kutch region in Gujarat. Why separate development board? These are the comparatively less development areas. So when you look at Western Maharashtra, that is Mumbai and surrounding areas, they are more developed. However, when you come to Vidarbha region or the Saurashtra and Kutch region of Gujarat, there is less development. That is why the constitution allows for separate development boards for this region. Okay, so report on the working of the boards has to be placed before the state legislative assembly every year. Every year report has to be placed. So these are with respect to the provision for Maharashtra and Gujarat. So next, what is the provision for Nagaland? Nagaland, article 371A. So they are right now demanding Greater Nagalim as a separate country or a separate state within the within India, in which involves territories of many states. They want some territories from Assam, they want some territories from Arunachal, they want some territories from Mizoram as well. So however, these states are opposed. So that is why they are carrying out armed insurgency. Armed insurgency in which form? We have NSCN Kaplang. They are doing the terrorist attacks. Insurgency. Okay. 371A. What does it say? The acts of the parliament relating to religious and social practices, Naga customary laws, and also administration of civil and criminal justice and land transfer of land. So in these four areas, the parliamentary laws are not applicable to Nagaland. So in these four areas, the parliamentary laws, acts of parliament are not applicable to Nagaland. It is said by which act? It is said by article 371A. So the governor of Nagaland has special responsibility. So special responsibility for law and order in the state. This is a very highly disturbed state with respect to law and order. That is why the governor of Nagaland has special responsibility when it comes to law and order in the state with respect to internal disturbances in the state. So the governor has to ensure money provided by the central government is included in the demand for grant. You already know what is demand for grant, right? So the central government provides money for the development of Nagaland, that has to be included in the demand for grant in the state budget. Okay. So the regional council consisting of 35 members has to be set up. A regional council consisting of how many members? 35 members has to be set up. So for which region? For Tuansang region. For Tuansang region. Tuansang region, a separate regional council has to be set up, right? So why? Maybe it is a very improvised province in the state. Okay, so So in this Tuansang region has to be administered by whom? By the governor. So with the aid of this regional council. So with the aid of this regional council, it has to be administered by the governor. The council of minister of Nagaland doesn't have any authority with respect to the Tuansang region. So Nagaland legislature, any act passed by Nagaland legislature does not apply to Tuansang region unless governor extends that law to that region. Suppose Nagaland assembly passes a law, that law is not extended to which region? Tuansang region, unless governor specifically extends that act. And the governor can make regulations for the peace and progress of this region. Okay, there shall be a Minister of Tuansang Affairs in the Nagaland cabinet. So these are the provisions with respect to Nagaland. Next is Assam and Manipur. Which act? Which article? Article 371B speaks of Assam. Article 371C speaks of Manipur. B and C. So, Article 371 majorly speaks about the tribal areas in the Assam. Tribal areas. How these tribal areas has to be safeguarded. That is what is spoken in the Article 371B. Okay. So, for the safeguarding of the tribal areas, a committee has to be set up. A committee has to be set up where? In the Assam Legislative Assembly. Assam Legislative Assembly. Out of the Legislative Assembly, a committee has to be set up for looking after the tribal affairs. Next comes Article 371C with respect to Manipur. So, here also a committee in the State Legislative Assembly can be created. For which region? For hill regions. Hill regions. So, wherever hills are there, for those regions, a committee and the MLAs from that particular region should form a committee. Okay. So, and also governor has special responsibility with respect to functioning of this committee. Governor has special responsibility, and governor should submit an annual report to the president. So, every year governor has to submit a report to the president with respect to the functioning of hill areas in the Manipur region. Okay, next comes the provisions for Andhra Pradesh and Telangana. So, Telangana was a new state. So, which is the article? Article 371D speaks of Andhra Pradesh, and E speaks of Telangana. Right? Okay. So, what does this articles denote? So, they denote that with respect to public employment, the president can make equal opportunities for all the people with respect to public employment. The first provision of this act, Article 371D and as well as E. Article 371D and E. What is that? It says President is empowered to provide equal opportunities for the public in the matters of employment and education. Okay, that is the first provision. Next is, for this purpose, the president can make provisions, may require the state government to organize civil posts. So, civil posts, that is government posts, has to be organized by the state government, and for those posts, direct recruitment has to be enabled. Direct recruitment from the local cadre, that is only the local people can get into those civil posts. No other person can get into that post. So, this is the provision only with respect to Andhra Pradesh, right? So, with respect to disputes with respect to that civil post. So, I said civil post will be created. So, whenever there is dispute with respect to those civil posts. So a tribunal, administrative tribunal has to be formed to deal with those disputes. Next is provision with respect to Sikkim. What is the provision with respect to Sikkim? Article 371F speaks about the special provisions to Sikkim. So what are the special provisions? So the state legislature assembly should consist not less than 30 members. The state legislative assembly should consist not at least 30 members. That is the first provision. Okay. So next provision is one Lok Sabha seat is allotted to Sikkim. One Lok Sabha seat is allotted to Sikkim. That is also given in this provision, Article 371F. Okay. So the governor has special responsibility with respect to maintenance of peace. The governor has special responsibility with respect to maintenance of peace in this region. Peace and for equitable arrangement and economic advancement. So economic advancement and maintenance of peace, the governor has special responsibility. That is responsibility outside the Council of Ministers. He can act in his own discretion when it comes to maintaining peace and as well as economic development. He need not take the aid and advice. Okay. This is with respect to Sikkim. Next is important provisions with respect to Mizoram. What are the provisions with respect to Mizoram? Which article speaks about it? Article 371G. 371G speaks about special provisions with respect to Sikkim, right? So the acts of Parliament, Parliament Act will not apply in these areas to Mizoram. What are the areas? Religious and social practices of Mizos. Mizo are the population of Mizoram. So religious and social practices of Mizoram, the acts of Parliament will not apply to that state. And also Mizo customary laws and procedure. Mizo's customary laws, that is traditional laws, there also parliamentary law will not apply. And also administration of civil and criminal justice with respect. So they have Mizo customary law. There also they have Mizo customary law. So the parliament's civil and criminal laws won't apply. So till when they don't apply? Till the state legislature, Mizoram state legislature extends. So if the Mizoram state legislature wants to extend the parliamentary law to Mizoram with respect to these three areas, that is customary laws and also social practices and also criminal and civil matters, civil justice. If the legislative assembly wants, then only they can extend. And also it says it does not consist less than 40 members. It won't consist less than 40 members where? In the Mizoram Legislative Assembly. Okay. Provisions for Arunachal Pradesh and Goa. So Article 371 speaks about, 371H speaks about Arunachal Pradesh. What does Article 371H speaks about? Okay. So the governor of Arunachal Pradesh has special responsibility. The governor of Arunachal Pradesh has special responsibility special responsibility for law and order in the state. For maintenance of law and order in the state, the governor of Arunachal Pradesh has special responsibility. Okay. And also the Arunachal Pradesh assembly will not consist of less than 30 members. That is also less than 30 members. That is also given in Article 371H. Goa. So Goa, Article 371I. So here also what does it say? Not less than 30 members in the state legislative assembly. That is said in Article 371I. So provisions with respect to Karnataka. So which is the article? Article 371J, latest of all the articles. So when was this enacted? The year 2012. In the year 2012, 371J was enacted with respect to the Hyderabad Karnataka region. So suppose this is the Karnataka state. This region is underdeveloped. This region is called Hyderabad Karnataka region. There in order to development, to provide for economic development, the parliament has enacted article 371J. So what does the article speaks about? It speaks about establishment of a separate development board for Hyderabad Karnataka. So separate development board for Hyderabad Karnataka. That is what is spoken by 371J. And also the reports of the board will be placed before the state legislative assembly every year. And also equitable allocation of funds for the developmental expenditure. Equitable allocation of the funds for developmental expenditure. Okay. So reservation of seats in the educational institutions. So reservation of seats in the educational institutions for people belonging to this region. And also even in government employment they have Hyderabad Karnataka reservation. Okay. So this is with respect to article 371J. Okay. So we have spoken about special provisions for the state. So next we will move to the very important concept, UPSC's favorite concept, Panchayati Raj. That is local government. Okay. So Gandhiji envisaged every village to be a republic, right? So that is local self-government, a village ruling itself, no higher authority, no authority from the higher end. So it has been established to build democracy at the grassroots level. To build democracy at the grassroots level, Panchayati Raj has been established. So which is the Amendment Act? So 73rd Constitutional Amendment Act. 73rd Constitutional Amendment Act 1992 provides for establishment of the Panchayati Raj. We have district panchayat, taluk panchayat, village panchayat. This is the hierarchy. So how did this Panchayat Raj evolve? Via these committee reports, it has evolved over time. So Balwant Rai Mehta committee was the first committee which spoke about Panchayat Raj. So what does it say? So it was established in 1957. So during that time there was community development program which was started by the government, central government, Indian government. So community development program was started in the 1950s, and to review that, this committee was formed. So what did it say? It said it recommended democratic decentralization, that is adding one more tier of government. So it said 3-tier Panchayati Raj, that is Gram Panchayat, Jilla Panchayat and block level Panchayat. Three level Panchayat has to be established, and it has to be directly elected. The members have to be directly elected. All the planning should be done by this Panchayat itself. Okay. And district collector should be the chairman of Zilla Panchayat. These are certain recommendations of the Balwant Rai Mehta committee. So after which Nagaur, Rajasthan was the first state to establish Panchayat Raj system. Rajasthan, so this fact is important from your preliminary perspective. Which state established the Panchayati Raj for the first time in India? It is the state of Rajasthan, right? So on October 2nd, 1959, in which district? The district of Nagaur. Nagaur. The district of Nagaur, Panchayati Raj was established for the first time in 1959 on Gandhiji's birthday. Okay. Next, there were many Ashok Mehta committee. Next comes Ashok Mehta committee. So what did this committee say? So it was established in 1977. So what did this committee say? So the committee said 3-tier Panchayati Raj system, similar to Balwant Rai Mehta committee. They also said 3-tier system, and also Zilla Parishad should be the executive body. That is the body, that Zilla Parishad should be the body which executes, which has executive power. So with respect to planning has to be formulated at the district level. Okay. So they also said, this committee also said political parties should fight the election at the Panchayati Raj level. So, and also it speaks about social audit of the projects at all levels, majorly at the district level, and also it speaks about Nyaya Panchayat. So we spoke about Gram Nyayalaya. So Ashok Mehta committee had spoken about it in 1977. When did the Gram Nyayalaya Act passed? 2008. So, and also there should be a chief electoral officer of a state. So for the conducting the panchayat election, there should be a chief electoral officer. Okay. Seats for SCs and STs should be reserved. And also Ashok Mehta committee said give constitutional recognition. This was the first committee which speaks about giving constitutional recognition to 3-tier government. Okay. There were many study teams and committees in between. So there are many study teams. So few of the study teams are Committee on Rationalization of Panchayat Statistics, Working Group of Panchayats and Cooperatives, and many other committees. So these committees names are not very important. So few of the committees were headed by famous people like K. Santanam. So study team on Panchayat Raj finances. So he was headed by K. Santanam. Can remember that one committee. Next comes GVK Rao committee. What did GVK Rao committee say? So who established the GVK Rao committee? So GVK Rao committee was established by Planning Commission, which was abolished in 2014 and replaced by Niti Aayog. So this Planning Commission established the GVK Rao committee in 1985. Why was this committee established even though there were two committees? So even after two committees had given recommendations, there was no improvement of a substantial level. So they said the Panchayati Raj institution has become not a grassroots institution but a grass without roots. That is, there was too much interference from the state government. So what did this committee say? So it lays emphasis on Zilla Parishad. That is, the central point of decentralization should be district level. That is Zilla Parishad. That should be the point of decentralization. Okay. So the planning should be taken up at district level. That is what this committee says. So there should be a district development officer. There should be a district development officer. Who says this? It was said by the GVK Rao committee. And also by elections to this committee has to be held regularly. That was said by GVK Rao committee. So next comes one more important committee, LM Singhvi committee. So out of these many committees, please remember few of the committees. You may remember Ashok Mehta committee, LM Singhvi committee, Gadgil committee. So 3 committees if you remember, more than sufficient. However, I am going to deal with all the committees in significant depth so that you know which committee said what. So LM Singhvi committee, it was formulated by or established by Rajiv Gandhi government in 1986, just 1 year after GVK Rao committee was established. So what did LM Singhvi committee said? So first and foremost, they said these Panchayati Raj institutions should have constitutional status. That is the first thing. Next, they said Nyaya Panchayat should be established. 2 important recommendations. So they also said the Panchayat should have taxation powers so that they become financially independent. So these are the 3 things said by LM Singhvi committee. Next we have Tungon committee. Tungon committee. What did Tungon committee say? So 1988, after 2 years after LM Singhvi committee was established, Tungon committee was formed. So what did they say? They also repeat that the Panchayati Raj should have constitutional status. So 3-tier system. They also say there should be 3-tier system. And they also lay emphasis on Jila Parishad should be the point of decentralization. So they also give the term, 5 years should be the term, just like state legislature and parliament, they should also have 5-year tenure. And also they say reservation of seats for women. So this is the first committee which says about reservation of seats for women in the Panchayati Raj. Today we have 1/3 reservation for women in the Panchayati Raj and municipalities. That is why there is very good representation. However, not at the level of state legislature and the parliament, because there is no reservation. 108th constitutional amendment bill, which speaks about 33% reservation for women in the state legislative assembly and parliament, is lying idle, not yet taken up. Okay. Tungon committee, these are the few things. They also say there should be a separate state finance commission which formulates division of resources between state government and the panchayats. So these are the important recommendations of Tungon committee. Next comes important committee before constitutionalization, Gadgil committee. What does Gadgil? VN Gadgil. So in the same year Tungon committee was formulated, 1988, even Gadgil committee was formulated. So 2 committees. This shows there is an evolution. The difference between GVK Rao to LM Singhvi to Tungon and Gadgil is going on reducing. However, here we see 20 years gap. So this shows there was an urgent need for setting up of the Panchayati Raj. So what does Gadgil committee say? First, constitutional status. Second, 3-tier Panchayati Raj, same. And also 5 years tenure, same. And also this committee gives one important recommendation saying that at all the levels there should be direct election. So MLAs and MPs are elected directly, right? Similarly, here also there should be direct election. Said by whom? Gadgil committee. And also, this Gadgil committee also says the Panchayat Raj body should have power to impose taxes and duties. So they also say there should be establishment of State Finance Commission. Next is the constitutionalization. So giving constitutional status to Panchayati Raj system. So this was first attempted by whom? First attempted by Rajiv Gandhi government. However, the bill did not pass because the opposition opposed the bill, right? Sorry. Next comes VP Singh government. VP Singh government, they also did not pass the bill because there was opposition. So, which government? National Front government. So, what was the opposition when VP Singh sir tried to bring this constitutional amendment bill for the constitutionalization of Panchayati Raj? So, it was not passed in the Rajya Sabha. So, it was not passed in the Rajya Sabha. So, that is even before it was passed, the government fell. So, this government lived for a very short tenure, right? Around 1 year or less than 1 year. So, because of which the constitutional amendment before being placed in the parliament, the government fell. However, the constitutional status were given by Congress government headed by Narasimha Rao, P.V. Narasimha Rao sir. So, what is the constitutional amendment? 73rd Constitutional Amendment Act. 73rd Constitutional Amendment Act of 1992. 73rd Constitutional Amendment Act 1992. Constitutional Amendment Act 1992. Right? Okay. So, what did this act do? This act added new part 9 to the constitution. Part 9 was added by 73rd Constitutional Amendment Act, and articles, new articles were added. Which were the articles? Article 243 to 243O. These many articles were added. This is not 0, this is O. Right? Look like a theta. Okay. Okay. So, in addition, the act also added one more schedule. So, one new part was added. These many articles were added. One more schedule. Which is the schedule? 11th schedule. You can remember. If you put this symbol 1 this side, it becomes the new part. If you put the symbol this side, it becomes a new schedule which was added, right? So, what is the significance of this Amendment Act? So, 40th Constitutional, 40th DPSP, 40th article, what does it say? It says village panchayat. So, that was implemented, say self-government, and also it gives constitutional status. So, till then it was the prerogative of the state either to form the Panchayati Raj or not. However, now constitutionally it is mandated that panchayats has to be formed. Next is, so there are many provisions under this. So there are compulsory provisions as well as voluntary provisions. What are the compulsory provisions? So voluntary provisions means so that it is left to the states either to implement. So it is one of the voluntary provision is that the states can either give representation for the socially and economically backward classes. The reservation for socially and economically backward classes is one of the voluntary provisions. Compulsory provision, reservation for women is a compulsory provision, right? Okay, what are the salient features of the act? So, first of all, Gram Sabha. Gram Sabha forms the foundation of this amendment. So, Gram Sabha means what? In a village, every elector who is eligible to vote forms the part of this Gram Sabha, right? It is a foundation. Every person registered on the electoral rolls of a village forms the part of the Gram Sabha. Next is 3-tier system. What are the 3 tier? 3 tiers: district level, intermediate level, village level. 3-tier system is established. Next is election of members and chairpersons. how the members and chairpersons are elected, right? So district, village and intermediate, that is taluka level, there is direct election. Okay, so the chairperson of a panchayat and other members are elected directly. So the chairperson of a panchayat at village level, so village level, so whenever they ask a question on panchayat raj, please make this diagram in the mains. So it fetches you 1 extra mark. District level, taluk level, village level. So village level chairperson is appointed or elected or nominated by any provision by how the state legislature provides. So how the chairman is elected at the village panchayat, it is based on state legislature law. However, taluk panchayat and district panchayat, the chairman is elected indirectly, not directly. The chairman is elected indirectly. Okay. So reservation of seats. The act provides for reservation of seats for whom? Scheduled caste, scheduled tribe in the panchayat raj, and also for women. Even in the case of chairman, even in the seat of chairman, there is reservation. Okay. So voluntary provision, backward classes can also be given reservation. Okay. Next is duration of panchayats. For how long these panchayats exist. So like the state legislature and parliament. 1 second. Okay. So like the state legislature and parliament, the duration is 5 years. So however, it can be dissolved before the 5 years. However, it can be dissolved before the 5 years by the state legislature. So if it is dissolved within 6 months, a new election has to be conducted, right? Okay, before 6 months, new election has to be conducted. Disqualification of members. So recently, Haryana state legislature formulated a law. So the law on direct democracy, that is recalling of the representatives. Suppose some representative is convicted of corruption or some illegal activities. So the people of Gram Sabha come together, or the panchayat level come together, they vote by more than, there is a specified percentage, 50 or 60%. If the vote get passed, that person stands cancelled. That is, he loses his seat. So what is the provision for disqualification? So disqualification provisions are made by states. From state to state, disqualification provision differs, right? So the disqualification is based on the laws made by the state legislature. Next comes State Election Commission. So we have Central Election Commission, right? Likewise, there is a State Election Commission which deals exclusively with the panchayat and municipality election. So there shall be a State Election Commission and also a State Election Commissioner, right? So he shall not be removed except on the grounds like a state judge of a high court. So State Election Commissioner can only be removed similar to a high court judge, that is only the parliament can remove, not the state authority. Okay, powers and functions of the Panchayat Raj system. So the state legislature provides for the powers and functions. So who provides for the powers and functions? It is the state legislature which provides for the powers and functions. First, so some of the powers may be, so the preparation of plan for economic development and social justice, that is one of the function, and also implementation of schemes for economic development and social justice. That is also one of the function. Okay, finances. What is the finance? So the state legislature can authorize. So the state legislature can authorize the panchayat to collect or levy tax, duties, tolls. So the state legislature can authorize the panchayat. Okay. And also the state government, that is out of the consolidated fund of the state, grants can be made to the state legislature. Grants can be made to the state legislature. So finance commission, for the panchayat raj system, there is a separate finance commission. So it shall be constituted after every 5 years. So what should be the function of this finance commission? The distribution of resources between the state and the panchayats. Distribution, just like central finance commission, state finance commission, what does it do? Distribution of resources between state and panchayats, right? So determination of taxes, duties and tolls. Determination of taxes, duties and tolls. And also grants in aid. Grants. What are the grants that the state government must give to the, what are the grants the state government must give to the panchayat? That is also determined. And also they give recommendations with respect to how the financial position of the panchayat can be improved. Panchayat's financial position, if it is not good, how it has to be improved, will be said by the state finance commission. Okay, audit and account. The state legislature can provide for audit and account of the accounts of the panchayat. Application to union territories. So the president can apply, extend these provisions to the even to the union territories. So exempted states and areas. There are certain states and areas which are exempted from this 73rd Amendment Act. Which are the states? Nagaland, Meghalaya, Mizoram, and also scheduled areas and tribes in these states. So these are certain areas where the hill areas in Manipur, Darjeeling district in West Bengal, these areas are exempted from this Panchayati Raj system, right? So to schedule areas and tribal areas, there is a provision for PISA Act, PISA, P-E-S-A. So that is extending the Panchayati Raj system to the scheduled areas and tribal areas. So normal areas Panchayati Raj system applies. However, scheduled areas and tribal areas, what do you mean by that? At Schedule 5 and Schedule 6. So Schedule 5 speaks about scheduled areas and scheduled tribes, right? So Schedule 6 speaks about tribal areas. Okay. So to that, if we have to extend the Panchayati Raj system, it is which act? It is the PISA Act. We will discuss that in a short while. Okay. So next is bar to interference by courts in electoral. So in the electoral proceedings, whatever happens, the courts cannot interfere. Okay. With respect to the elections of panchayats, the courts cannot interfere. Sorry. 11th schedule. So I said 11th schedule was added. So what are the items under 11th schedule? There are 29 functional items, 29 items, just like union list, state list. So this schedule 11 gives 29 items to the panchayat. What are the 29 items? Agriculture, land improvement, minor irrigation, fisheries, social forestry, minor forest produce, rural housing, drinking water, so on. So just remember few of the points. It is more than sufficient. Next is, I said there are certain compulsory provisions and certain voluntary provisions. What are the compulsory provisions and what are the voluntary provisions? Okay, compulsory provision. Organization of Gram Sabha, that is a compulsory provision. Establishment of panchayats at all the levels, compulsory provision. Indirect elections to chairperson, post of chairperson, compulsory provision. Okay, 21 years to be the minimum age. So, say MLA election, what is the minimum age? 25 years. MP election, 25 years. Panchayat election, 21 years. That is a compulsory for provision. Reservation of seats for women, SCs, STs, compulsory provision. Likewise, there are many compulsory provision. Okay, what are the voluntary provisions? Voluntary provision means the it is done by the discretion. So the state can either implement it or may not implement it. So what are the voluntary provisions? Okay, so what are the voluntary provisions? Determining the manner of election of chairperson. I said village panchayat chairperson depends on the state law. So that is a voluntary provision. State can provide any manner of election. Next is providing reservation of seats to backward classes. That is also voluntary provision. And also devolution of powers to panchayats and prepared plans. That is also voluntary provisions. So devolution of powers. So state, if it wishes, if it can devolve the powers, and also planning powers. Granting financial powers to panchayats, voluntary provision. It need not be mandatory. And also making grants in aid to the panchayats. Panchayats, money would be granted to the panchayats from the state. So that is a voluntary provision. State, if it wishes, it can do. If it doesn't wish, it need not do. So now we will speak about the most important act, PISA Act 2017. There was a question in the mains, right? So PISA Act forms part of which part of Constitution? Part 9. Part 9 of the Constitution. Okay, so part 9 of the Constitution does not apply to panchayats when in the 5th schedule areas. There are 5th schedule areas. In the upcoming classes, I am going to discuss what are the 5th schedule areas. Okay, in the 5th schedule areas, the panchayat system is the part 9. That is, panchayat system is not going to be applicable. So, how to apply to these states? That is, what is the in the schedule areas, how to apply the panchayat system? How to apply the panchayat system in the schedule areas? Via this act, PISA Act, Panchayat Extension to Schedule Areas Act of 1996. Okay, so what is the objective of PISA Act? So to extend part 9 to schedule areas, that is the main objective. To provide self-rule for the tribal population. So, tribal population, the PISA Act provides self-rule. So, there are two types of land. One is revenue land, another is tribal land. So, it is said that this PISA Act brings the tribal land into revenue administration. Revenue administration means what? Tribal administration means what? Under their own administration. The state government doesn't have any authority. Revenue administration means the revenue department has an authority. The revenue minister has an authority. That is, the tahsildars and district collectors have authority over what? Over the tribal land. This PISA Act ensures that. Okay. Next is, we are discussing about the objectives. It provides for self-rule of the tribal population. Okay, that is one thing. Next is, so it makes Gram Sabha a nucleus of all activities, a center point of all activities. It evolves suitable administrative system with the consistent with traditional practices. So tribal areas has many traditional practices. So this PISA Act evolves administrative system which is consistent with which is consistent with tribal administration. Okay, next we will discuss some of the features. What are the features of the PISA Act? So the state legislation on panchayats in scheduled areas. So the features of the PISA Act are: suppose a state forms a legislation on the panchayats in scheduled areas. So in scheduled areas, PISA does what? Extends the panchayats to scheduled areas, right? So if the state forms a law, it has to be in consonance with the customary law. So that is customary law. Tribal laws, these state laws should be matching, or it should not breach the boundary of customary law. So the village shall, it also gives the features. It also gives the definition of a village, definition of what is a tribal village, that is given by PISA Act. So the PISA Act also says about every village should have a Gram Sabha. Every village should have a Gram Sabha, that is given by PISA Act. So every Gram Sabha should do certain functions. What are the functions? It should preserve the traditions, customs of their people. That is also given in the PISA Act. So Gram Sabha also does certain other functions. What are the functions? It approves the plans, programs and projects of social and economic development. Plans, projects of for social and economic development. Utilization of funds. So every panchayat at the level, village level should obtain from the Gram Sabha a certification of utilization of funds. Okay, funds are granted to the village Gram Sabha, right? So to utilize these funds, there will be, so what is the difference between Gram Sabha and Gram Panchayat? Gram Sabha involves all the voters. Everyone in the village are part of Gram Sabha. Whereas Gram Panchayat is those who are elected. Those who are elected to the village Panchayat, they form the Gram Panchayat. So this Gram Panchayat utilizes the funds, right? So they should utilize the fund with the consent of Gram Sabha. So it is a measure of direct democracy. Okay. So these are some of the features of PISA Act. Okay. Next is financing of Panchayat Raj. How the finances are made. Okay. The second Administrative Reforms Commission. Who was the chairman? Former Chief Minister of Karnataka, Veerappa Moily ji, was the chairman of second ARC. So, what is this second ARC say about the financing? So, it says, structural empowerment of Panchayat Raj institutions. How? Via grants from Union government. So, Union government should also give grants to the Panchayat Raj institutions. That is what is said by the second Administrative Commission. Also, devolution from the state government. So, state government should also give funds to the Panchayat Raj institution. And also, loans from the state government to Panchayat Raj institution. The second ARC speaks about that. Okay. So it says that across the country, many states have not done sufficient financial devolution. So not many states have done sufficient financial devolution. That is, financial power is concentrated in the state government. These panchayat institutions doesn't have any financial or many major financial power. That is what is said by the second Administrative Commission. So there are, it says there are many weaknesses in the finances of Panchayat Raj institutions. That is what is pointed out by second Administrative Commission. Okay. Okay, next is so it gives a elaborate description of the finances of Panchayati Raj. So what is the condition of finance? So is there sufficient finance at the Panchayati Raj? So if not, what should be done? Everything is spoken about by the second administrative commission. So majorly it focuses on what are the problems. Okay, reasons for ineffective performance. What are the reasons for ineffective performance of Panchayati Raj? Lack of adequate devolution. So whenever Panchayati Raj system comes, this diagram is important, and one more term is important. 3F. 3F means funds, functions, and functionaries. Funds, money, functions means work, functionary means workers. These three terms are important. Okay. So lack of effective devolution, that is the first reason for non-effective, ineffective performance of Panchayati Raj institutions. Next is excessive control of bureaucracy. Bureaucracy exercises disproportionate control over PRIs. Next is tied nature of funds, that is you do certain things, then only you will get certain funds. That is, so the funds are based on performance. That is also a reason. Overwhelming dependency on government funding. So the Panchayat Raj institutions depends on the government funding. That is also a drawback. Next is, so creation of parallel bodies. So with respect to at the district level, there is district panchayat, there are also district collector and various other authorities. So they exercise disproportionate power. Next is poor infrastructure. There is no good infrastructure for this Panchayat Raj institutions. Okay. So we have finished the chapter on Panchayat Raj system. So what are the important articles? The article majorly which deals with is 243. It goes up to 243O. 243O. Okay. So Panchayat Raj institutions and evolution. So suppose if there are 3-level panchayats, there are also 2-level panchayats. So for example, Manipur has 2-level panchayats. What are the 2 levels? Gram Panchayat, Zilla Panchayat. Even Sikkim has 2 levels. However, UP has 3 levels. Gram Panchayat, Kshetra Panchayat, Zilla Panchayat. Karnataka also has Gram Panchayat, Taluk Panchayat and Zilla Panchayat. 3 levels. Okay. Evolution of Panchayat Raj institutions. So, first generation evolution. So, there are many generations of panchayats. So, 3 generations. 2 generations plus 1 constitutional generation. One is towards first generation. First generation we have this community development program. We have Balwant Rai Mehta committee and also first Panchayat Raj started on in Rajasthan. That forms the first generation. So you have to write there are many generations. So there are first generation, these 3 points if you write more than sufficient. Next is second generation panchayats. So second generation panchayats, we have West Bengal forms panchayat system, Ashok Mehta committee comes, Karnataka forms a new Panchayat Raj Act in 1983, Andhra Pradesh forms Act. So this forms the second generation. So third is constitutionalization of Panchayat Raj. So constitutionalization, we have LM Singhvi committee, we have Tungon committee, we have Gadgil committee and various, so 2 constitutional amendment acts forms the constitutionalization of Panchayati Raj. Okay. So this is with respect to your Panchayati Raj system. Next, municipalities. So the chapter on panchayats are very important. However, municipalities can be of lesser importance. Okay, evolution of urban bodies. How urban bodies evolved in India. So urban local government. So there are, so you know what is urban local government. In Bangalore we have BBMP. In also in Mumbai we have a separate Mumbai Municipal Corporation, MMRD something, I don't remember the name. So what are the types of, there are 8 types of urban local government. What are the 8 types? Municipal corporation, municipality, notified area committee, town area committee, and cantonment boards, townships, port trust, etc. So which is the constitutional amendment? When it comes to municipalities, it is 74th Constitutional Amendment Act. Okay. So who has control over this? Which ministries? So Ministry of Urban Affairs majorly. In case of cantonments, it is Ministry of Defence. So even I said cantonment boards. Cantonment boards, who governs? It is the Ministry of Defence. With respect to Union Territory urban bodies, it is Ministry of Home Affairs. This difference is important from your prelims perspective. Evolution of urban bodies. Evolution of urban bodies. How did urban bodies evolve in India? Historically, first municipal corporation in India, 1688. Where did it set up? Madras. In 1726, municipal corporation in Mumbai, so that is Bombay and Calcutta. Next is 1870. Lord Mayo's resolution. Lord Ripon's resolution. When does it come? 1882. Next, 1907. There is a royal. So Mayo resolution and Ripon's resolution. Both of them speaks about. So we will discuss that in the topic on history, in the history chapters. So both of them speak about urban local government. Next, we have Royal Commission on Decentralization. There is a UK committee, British committee, which comes to India, which speaks about decentralization. Royal Commission on Decentralization. Also, we have diarchy in 1919. There, this local self-government becomes a transferred subject. Okay. So 1935 Act, local self-government was made a provincial subject, that is under the state governments. Okay. So historical committees and commissions. What were the committees? Just like all those committees, here also we have many committees. However, the committees in municipalities are not very important. So, in 1989, Rajiv Gandhi government tries to introduce a bill for constitutionalizing of urban local bodies, urban local government. So, first we will look at then even National Front government by VP Singh sir also tries to constitutionalize. However, who does it finally? It is P.V. Narasimha Rao ji. So 74th Constitutional Amendment Act was enacted. So what are the committees and commissions? So I said committees and commissions are not very important. However, you can remember one committee, Charles Correa Committee. You know this, he is an urban designer who passed away some 5-6 years back. Charles Correa Committee on National Commission of Urbanization. So this one committee, 1985. If you remember this one code, this one committee, it is more than sufficient. So 74th Amendment Act 1992. What does it say? Which part of article? Which part of the Constitution it belongs to? It belongs to Part 9A. So Panchayati Raj systems belongs to Part 9. This belongs to Part 9A. So which are the articles? So Panchayat Raj ends at 243O. This begins from 243P and goes up to 243Z. Z, so it also continues after Z, right? ZG. So after Z, ZA, ZB, ZB, ZC up to ZG. So it goes up to ZG. Okay. So 74th Amendment Act gives constitutional status to this municipalities. Okay, what is the salient features? Salient features of 74th Amendment Act. So it creates 3 types of municipalities in every state. Every state there are 3 types of municipalities. What are the 3 types? Okay. So the first type is Nagar Panchayat for a transitional area, that is a smaller urban area which is transitioning into a urban area. For that, Nagar Panchayat. Municipal Council for a smaller urban area. Smaller urban area, Municipal Council. Municipal Corporation for a larger urban area. For a big area, it is Municipal Corporation. Okay. So, how does this areas are determined? So, they are determined on the population, density of population, revenue generated, percentage of employment in agricultural activities. On these criterion, the types of urban government are determined. Okay, next is what is the composition? What is the composition of this municipalities, right? So there is direct election, right? There is direct election. There is no provision of indirect elections. So for this purpose, each municipal area shall be divided into wards. So suppose there is one municipal area, there are divided into many wards like this. There are ward committees also. Okay. So representation of following persons in the municipalities. In the wards, there are many. In the municipality, many special categories of persons are represented. So who are the persons? Persons having special knowledge in municipal administration, members of Lok Sabha and State Legislative Assembly, Rajya Sabha, local MLCs, they can also be represented in the municipalities. So ward committees, every ward there will be one ward committee. What is a ward committee? Consists of one or more wards. So it is not for one exclusive ward, it can be for more wards also. It can be for one ward also, it can be for more wards also. One or more wards. So having a population of 3 lakh or more. So what is the composition? The composition depends on the law made by the state legislature. So whatever the law made by the state legislature, based on that these committees are formed. Okay. Reservation of seats, like in the panchayats, here also we have reservation for SCs, we have reservation for STs, we have 1/3 reservation for women also. Also the state government voluntarily can provide for reservation for backward classes as well. So duration of municipalities, what is the duration? The duration is just like Panchayat Raj, State Legislative Assembly and also the Parliament, it is 5 years. Okay. So if it is dissolved before 5 years, the election has to be conducted within how many months? 6 months. Okay. So disqualification. So disqualification is based on the what? Similar to Panchayat Raj, based on the law made by the disqualified law made by the state legislature with respect to with respect to Parliament and State Legislature, we have what? Representation of People Act, RPA 1951, right? With respect to panchayats and municipalities, state legislature forms their own law. Okay, so there is a state election commission to conduct the elections. There is a separate state election commissioner and state election powers and functions. What are the powers and functions? So the state government, the state legislature can give the municipalities with such powers and authorities as it may deem necessary. It is the prerogative of the state legislature to devolve the powers. So these powers are of two nature. What are the powers and functions? So one is planning for economic development and social justice. Next is implementation of schemes for economic development. For economic development, certain schemes are implemented. That is also falls as a function of the municipalities. Next is finances. The state legislature can authorize the municipalities to collect taxes. And also it can also assign certain taxes out of its consolidated fund of state. It can say this percentage goes to municipalities. So also it can give grants in aid, certain grants based on State Finance Commission. Okay, we have a State Finance Commission similar to Panchayat Raj. So it speaks of the distribution of revenue for municipalities, determination of taxes and tolls which that may be collected by the municipalities, the measures needed to improve the financial position of municipalities, and also how much grants in aid need to be given for the municipalities. Okay. So even the Central Finance Commission also says what are the measures needed to strengthen the finances of the municipalities. So audit of accounts will be done of the municipalities, and the president can apply this to Municipality Act to even union territories. That is also there. So here one special category is there, not seen in the panchayats. So what is it? District Planning Committee. So District Planning Committee. Every state shall constitute at a district level a District Planning Committee to consolidate the plans prepared by panchayats and municipalities. So District Planning Committee consists of members from both panchayats and municipalities. So it consists of members from both panchayats and municipalities. Okay. So what are the functions of this District Planning Committee? So they found out they plan for the district. That is the primary function. Next is how to augment the resources, how to find resources for the district. That is also the work of them. And also matters of common interest for municipality and panchayat. So municipality is also there in a district and panchayat is also there. What are the matters of common interest to both? So that is also the function of the, so finding out that is also function of the District Planning Committee. So majorly what you have to remember, it consists of members from panchayats and as well as municipalities. Okay. Metropolitan Planning Committee. Metropolitan Planning Committee, metropolitan area, that is the areas like Bengaluru, Delhi. Okay. So here also it consists of both members of municipalities as well as chairmen of panchayats. It consists of members of municipalities as well as, so here one special difference is there when it comes to District Planning Committee. District Planning Committee, panchayats and municipality members. Metropolitan Planning Committee, municipality members plus chairmen of the panchayats, not the members. Chairmen of the panchayats will be the members of municipality planning committee. So what are the functions? So they formulate a plan, that is for the metropolitan area, that is the first function. Second is augment the resources, that is the second function. And third is the find common areas of interest for working. So and also augmenting resources, that is also there. And also finding common areas of interest, that is also the work of this metropolitan planning committee. Okay. Next is next comes with respect to municipality elections. Courts are barred from intervention. Courts cannot intervene in the elections of the municipalities. 12th schedule. 12th schedule. What does it speak about? 12th schedule. What does it speak about? So we have 11th schedule for panchayats, 12th schedule for municipalities. It has how many items under it? It has 18 items. How many items are there in 11th schedule? 29 items. Here we have 18 items. What are the 18 items? Few of them you may know. Urban planning, land use, roads and bridges, water supply, public health, fire services, urban forestry and many other things. Okay. Next is types of urban government. Types of urban governments in India. First is municipal corporation. So municipal corporation are created for big cities: Delhi, Mumbai, Kolkata, Chennai, Bengaluru. So these areas have municipal corporation. So municipal corporation has how many authorities? It has 3 authorities: council, standing committee and commissioner. So council consists of councillors elected from the wards. So they form the part of the council. And also there is a mayor. The council elects a mayor whose tenure is for 1 year. Okay. So standing committee are created to facilitate the working of the council. Just like parliament has parliamentary standing committees, these councils have standing committee which are act as deliberative bodies. Small chunks, small bodies, they act as deliberative bodies. Next, there is a municipal commissioner. Okay. Next is municipality. What is this municipality? It is a smaller version of municipal corporation. So it is administration of towns and smaller cities. Okay. Municipality consists of 3 authorities. What? Similar to the municipal corporation. What are the 3 authorities? First is council, second is standing committee, third is chief executive officer. There we have commissioner, here we have chief executive officer. So the council is a deliberative body. You know that wards, councillors come there. So it is headed by a president or chairman. Corporation, mayor, here president or chairman. Standing committees are created, similar chief executive officer. Next is notified area committee. So notified area committee. Notified means who notifies it? It is a fast developing town due to industrialization. Notified area committee is a fast developing town due to what? Due to industrialization. Okay. Okay. So it is established on the notification by the government gazette. That is why it is called a notified area. So state government notifies the area by a government gazette. That is when gazette means what? It is an official document of the government. So if the area is notified by the gazette, it is called a notified area committee. So what authority rules the notified area committee? So here there is a council. which is entirely nominated body. There is no election. Notified area committee members, all the members of the committee are nominated. There is no election. Okay, there is no elected body. It is a nominated body. Next is town area committee. Next we will speak about town area committee. What is town area committee? So it is created for administration of a small town. Small town administration is created by a which authority? Town area committee. Okay. So it may be wholly elected or wholly nominated. Maybe wholly elected committee or a wholly nominated committee. Next comes cantonment boards, which is under the Ministry of Defence. So it is, so cantonment board, there even in cantonment area there is civilian population, right? So to administer the civilian population, cantonment boards are enacted. So there is an act, which act? Cantonment Act 2006. 2006 Cantonment Act. Okay. So there are present 62 cantonment boards. 62 cantonment boards. So these boards are partly elected and partly nominated. So the commanding officer, the military commanding officer of the station acts as the chairman of the board. So the vice president is elected by the elected members. So the vice president is elected by the elected members. So partly elected, partly nominated. The elected members nominate the or elect the vice president. So it functions similar to the municipality but in a cantonment area. Next is the township. Township majorly where industrial area. We had Kudremukh township when mining was happening there. So there is it is a type of urban government established by large public enterprise. Large public enterprise. You have Bhilai steel plant, we have Tisco and all those steel plants there. These townships are created, and these townships, so there will be an administrator for the township. So this township provides civic amenities, that is water supply, electricity and everything to the residents of the township. Who heads it? It is a town administrator. Next comes port trust. So we have Jawaharlal Nehru Port, Marmagaon Port, Visakhapatnam Port, Tuticorin Port. In these ports, major ports. How many ports? Major ports, 12 ports. So this port trust is established to manage and protect the ports and also to provide civic amenities. Manage the ports, provide civic amenities. Recently there was Act 2019 or 20. Major Ports Act, current affairs. Okay. Next comes Special Purpose Agency. Special Purpose Agency. So, in addition to these 7 area based. So, these are area based urban bodies, right? These whatever I spoke about till now. So, there are special purpose. Our BDA, BESCOM, BWSSB, all these are special purpose body. BDA means Bangalore Development Authority, BESCOM for electricity, BWSSB for water supply. All these are special purpose body. The type of special purpose bodies are town improvement trusts, urban development authorities, water supply and sewerage boards, housing boards, pollution control boards and other such bodies. Municipal personnel. So, municipal personnel, who are the persons working. So, there are many types of personnel system. That is worker system. So separate personnel. So in some states there is separate personnel, separate municipal workers cadre. Okay. Unified personnel system. In the states like Karnataka, there is unified personnel system. Sorry, not in Karnataka. In the Tamil Nadu, there is a unified personnel system. That is, so there is a What we have to understand unified personal system in difference with the separate personal system. Under this system, each local body appoints its own personal. Bangalore local body, Bangalore personal. So Mangalore local body, Mangalore, Mysore personal. Whereas unified personal system, so whole Karnataka municipal bodies together hire the personnel. They can be transferred from one municipality to another municipality. Another kind of system is integrated personal system. Here the state government employees come to municipality working area, municipal corporation employees can also go to work in state administration. This is integrated personal system. There are many institutes of so-called self-government. So we have All India Institute for Local Self-Government, certain institutes, and Regional Center for Urban and Environmental Studies, a National Institute for Urban Affairs. These are certain institutions. Municipal revenue. So municipal revenue, what are the kinds of revenue? One is the tax revenue. What are the kinds of tax revenue? Property tax, entertainment tax, advertisement tax. We see these advertisements, big advertisement hoardings. So the taxes go to municipality, BBMP in Karnataka. Water tax, lighting tax, market tax, and many other taxes. So non-tax revenues. Non-tax revenues means so fines. So BBMP marshals impose fine when you don't wear masks, right? That fine goes to non-tax revenue. And rent on municipal parties, municipal properties. We have BDA complexes, site places. So the people who rent it out pay the rent. That also is a non-property, non-tax revenue. Next we have profits and dividends and interest and other things. Grants. The central government and state government provides grants. That is also revenue. Devolution. Devolution means the state government gives certain percent of its revenue to the municipalities. That is also revenue. Loans. So these municipal corporations get loans. So from various authorities, from state governments majorly, and also financial institutions. That also forms part of its revenue. So here one concept, current affairs. Municipal bonds, muni bonds. So we have Pune Municipal Corporation which has enacted municipal bonds. Next we have Central Council of Local Government. So it was set up in 1954, constituted under which act? Constituted under Article 263, Interstate Council. So this council, what does it do? So it tries to propagate self-government. It tries to propagate self-government. So it is a council, is an advisory body. It is an advisory body. Not recommendations are not compulsory. So under which ministry? Ministry of Urban Development. The council performs following functions. What are the functions? Recommends policy matters, making proposal for legislation, examining the possibility of cooperation between center and states, and many other, recommending central financial assistance and many other works. Okay, what are the articles? I already said Article 243P to 243ZG. So until till those articles, it is important. Name of urban local bodies. So suppose in the case of Andhra Pradesh, we have municipal corporations, municipalities, and Nagar Panchayats, 3 levels. So in the case of Goa, only 2 levels, municipal corporation, municipal councils. In Karnataka, city corporation, city council, town panchayat. In Tamil Nadu, municipal corporation, municipality, and town panchayat. Different states have different nomenclature. Okay, we'll today end the class with the municipalities. Tomorrow we'll pick up union territories and other things. We have still 2 more days of polity left. I have still many parts to cover. That is, we have majorly constitutional and non-constitutional bodies and some areas of the state government, still some areas, that is union territories and schedule areas. Those have to cover. Okay, hope you found the class useful. Please make good use of it for your revision and clearing of the concepts. If you have any doubts, please do reach us through our Telegram channel. I provided the link in the beginning of the class, and I hope you enjoyed the class. Thank you. Jai Hind. Namaste.